Robert, you want to come introduce our guest?
Okay, thank you everyone for being here. We're honored to have Justice Brett Busby with us. Let me tell you a little bit about him. He has a remarkable story. A seventh generation Texan, a third generation Eagle Scout, a violinist who played with Houston Symphony. He had a courtroom romance meeting his wife Erin at the U.S. Supreme Court when they both clerked for different justices. They have two kids they live in Austin now, of course, with being in the Texas Supreme Court. They have two kids there. Erin is an adjunct professor at the University of Texas Law School, and then spends some time also with her two kids at home. Justice Busby first was on the court here in Houston's 14th Court of Appeals, and then was appointed last year to the Texas Supreme Court by our Governor Greg Abbott. He is what I would call a textualist or an originalist. He is active in the Federalist Society, as I think all the lawyers in the church are here, Federalist Society, and so he has a great, what we would call a great judicial philosophy. But we've asked him to come, though, with things being in the news now, with the appointment by President Trump of Judge Barrett to the U.S. Supreme Court, to talk about why it's so controversial, these Supreme Court appointments, why it shouldn't really be that way, talk about what judges are supposed to be doing, and then, of course, there'll be time to ask your questions. So join me in welcoming Justice Busby, please. Thank you.
Well, thank you, Robert, and Pastor, thank you for having me. Good evening, ladies and gentlemen. I'm Brett Busby, and it's an honor to be with you this evening. Robert suggested that I just talk a little bit about my background and how I came to serve on the Supreme Court to start, and so I'll do that. As he mentioned, I'm a seventh-generation Texan, third-generation Eagle Scout. Grew up mostly in Amarillo and then in Austin, but have lived for the last 20 years in Houston until we just recently moved our family to Austin with my new responsibilities on the Supreme Court. So this is an area that I have a lot of love and fondness for, and so it's a pleasure to be back in the Houston area with you all tonight. And after graduating from high school in Austin, went away to Duke undergrad and then Columbia for law school. And, it's funny how my inspiration for going to law school was my mother. Both my parents are lawyers, actually, but particularly my mom. She was the only woman to graduate in her law school class from St. Mary's Law School in 1971, when we didn't have a lot of women in the legal profession. And she couldn't find a job coming out of law school as a lawyer. And so she drafted bills for the legislature for a year and then had me. And then when I was in school, she decided to look for legal employment again and found a more senior woman in the legal profession to be her mentor and kind of help train her in doing trust and estates work. And she eventually ended up litigating cases in federal tax court, and she never lost a case. Because she was often underestimated, but she was willing to work hard and put in more work than anybody else on the case. And so I saw her, her determination and her approach to the law, and it really inspired me as something that I might like to do as well in my career. And so I would read her legal brief sometimes when I was in high school and got a sense of what that was about, and thought I might actually follow her into tax litigation. But it's funny how the Lord puts people in your path to suggest things that may be an even better path for you. And one of my professors when I was in law school said, you ought to think about being a law clerk for a federal judge after law school. Even if you're going to do tax litigation, that would be good experience for you to have, to go work for a judge for a year and then go out into your practice having learned some from the judge about what's effective in the courtroom and that sort of thing. And so I took his advice, and I was able to get a clerkship with Judge Jerry Choflat on the U.S. Court of Appeals in Florida, who was a wonderful mentor. And then that same professor said, you ought to think about applying for the U.S. Supreme Court. And he said, by the way, don't forget to apply to the retired justices, because if they're still hearing cases, they get to take one law clerk and have that law clerk help. And so I took his advice, and again, I was hired by Justice Byron White at the U.S. Supreme Court, who was already retired but was still taking law clerks and hearing cases on the courts of appeals. And so I did get to work with Justice White, and they don't really have enough to keep you busy full time, so they share you with some of the active justices on the court as well. So I got that experience working at the court. I got to work for more than one justice in the same year, which was a real honor. And as Robert mentioned, I also met my wife, Erin, who was a law clerk the same year for another justice. And so it was a wonderful year for us, both personally and professionally, doubly blessed to be there at the Supreme Court. But I had always thought that I'd like to come back to Texas and start my career here. And so I came back, and with talking with different people, I knew at that point I wanted to do appellate work and litigate the kinds of cases in the kind of courts where the judges I had been working for were working. Because in our courts, of course, every case starts out in a trial court, and the case may be decided with or without a jury, depending on how clear, whether there are any factual disputes that a jury needs to resolve, and then the judge will decide what the law is that applies to the case. But if you don't agree with the result in trial court, you have one guaranteed right of appeal to a court of appeals that looks at, did the judge get the law right? And if there was a jury, was there enough evidence to support whatever verdict they reached in the case? And I really enjoyed that type of work because it's a lot of research and writing, and that just suited my personality. And also you get to stand up and do oral arguments just to the court. We don't talk to juries in appellate courts. And so you're just basically having a dialogue with the judges about the law and how it applies to the particular case. And so I really enjoyed that type of practice I found through my clerkships and knew that's what I wanted to do. And some people said, you should really go to Houston if you want to have that kind of practice, because we've got such a diverse legal community here, so many different kinds of companies and individuals and different kinds of cases, that it's easier to support a practice like that. So I came to Houston in 2000 and started my practice here, and ultimately became a partner at Bracewell, one of our firms here, doing appellate work all across the country, actually. Had a chance to argue one case in the U.S. Supreme Court where I had served as a law clerk. Did that on a pro bono basis, and also argued several cases in front of the Texas Supreme Court, and where I now serve, and the local Court of Appeals, the 1st and 14th Courts of Appeals here in Houston, where I previously served. And I really enjoyed my law practice and was able to build a very successful practice. And it also gave me an outlet to volunteer my time for causes that were important to me. I spent hundreds of hours doing what we call pro bono, free legal work, when I was in private practice on a range of topics, including freedom of religion. I worked with a group up in the Dallas area that focuses on this. It's called First Liberty Institute, that focuses on religious freedom cases in particular. And through some of this volunteer work, I actually had a chance to meet then Attorney General Abbott, who was going to be going to the U.S. Supreme Court to argue to defend our Texas Ten Commandments monument, which had been challenged. There's a monument on the Capitol grounds. If you haven't seen it, next time you're in Austin, you should stop by. It's between the Capitol and the Supreme Court building, and it has the Ten Commandments on it. And there are lots of these monuments around the country, and some groups had been challenging them, and the Texas one had been challenged, and the U.S. Supreme Court agreed to hear the case. And Attorney General Abbott was going to argue the case himself, and Ted Cruz, who was his Solicitor General, knew my wife and I because we had all clerked at the Supreme Court, and so he invited us to come and help get Attorney General Abbott ready for that argument, to pretend to be justices and ask him hard questions, and so that he would be ready for the kinds of questions that he might hear from the justices. And he told this story at my investiture. My wife said, I think you may be able to get Justice Breyer's vote in this case, and why don't you think about, this issue, and he may ask you about that, and maybe you should emphasize this. And he ended up winning that case by a 5-4 vote, and Justice Breyer was the 5th vote in that case to uphold the Texas Ten Commandments monument. So we were blessed to have a lot of great experiences like that, volunteering our time for causes important to us. And I also, from time to time, would have frustrations with my law practice because I would end up in front of judges where I really felt like they didn't have a good understanding of what the proper role of a judge was. And just to give you a couple of examples, sometimes I really felt like the judge would sort of look at the parties and decide who he or she wanted to win and then look for a legal reason to get there, even if the parties weren't arguing that legal reason at all. And then other times, you really got the feeling that the judge wanted to change the law in a particular way and was looking for a way to get away from what I felt like the law clearly said in the case. And so I expressed my frustrations to my wife about that one too many times perhaps, and she finally said, "Why don't you do something about it?" As good spouses do, she saw that potential role for me, and so encouraged me to run. And about a year later, an opening came up on one of our local courts of appeals here, the 14th Court of Appeals that serves Harris County and 9 other counties in this area. And so I ran for that seat and was elected in 2012 and served for 6 years on the Court of Appeals here in this area, and then came up for election again in 2018 and was swept out with the straight ticket vote in 2018. So I lost my 2018 election and was praying about what to do next. And about that time, I'd always thought, what an honor and a pleasure it would be to have a chance to serve on the Texas Supreme Court, having argued cases there. And I had applied for positions when they'd come open in the past and had never been selected. And at this time, as I was trying to decide what's next for me and praying about my path, one of the justices on the court retired. And so I applied to the governor and was appointed in his place. And so I feel it's funny how things work out in life sometimes. I ended up losing my position on the Court of Appeals to get my dream job on the Texas Supreme Court. So I feel so honored and blessed to be there, and it's a real privilege to serve in that way, and with folks that I greatly admire and some of my mentors who are on the court. And just to talk a little bit about what we do, and then I want to get into some of the issues about judicial selection that we were talking about as well. But we're the highest civil court in the state. And so I mentioned earlier, the cases start out in the trial court, and if you don't agree with what happens there, you can appeal to the Court of Appeals, whether it's a civil or a criminal case. And then they examine whether the judge got the law right, and if there's a jury, whether there was enough evidence to support their verdict. And but always deciding cases based on at least in my view, if you're doing it correctly, always deciding cases based on the arguments that the parties make, not based on our personal view about who ought to win and then coming up with a way to get there. Because we have an adversary system of justice in this country that we inherited from the English system, where the judges are the neutral arbiters of the arguments that the parties bring to us. We don't get to decide how they're going to prosecute their case. They get to decide which laws they're going to rely on and which theories and how they want to present it to the court. And then the other side gets to make their arguments, and we're there as a neutral party to decide the case based on the law as it is, not based on any personal preference. And I feel very strongly about that. The one case I argued in the U.S. Supreme Court was actually on that subject because we had an issue where it was in a criminal case, habeas corpus case, which is sort of a specialized post-conviction proceeding in criminal cases. And the issue there was, could the judge throw out the case based on it being untimely, even though no one had made that argument in the case? And normally the answer would be no. Judges aren't supposed to make those sorts of arguments if a party's not raising it. It's called the statute of limitations. But the particular issue in this case was because of this specialized sort of post-criminal conviction context, is there an exception to that or not? And we ended up losing that case 5-4, with Justice Ginsburg writing the opinion saying, based on some of the unique considerations in this area, the judge could throw out the case on his own without anybody raising this argument of timeliness. And Justice Scalia ended up writing the dissent in my favor, joined, interestingly, by Justice Stevens, Justice Thomas, and Justice Breyer. So it doesn't always break down on the lines that you might suspect from reading media coverage of the U.S. Supreme Court, because they were appointed by presidents of different parties, but they really felt very strongly about the adversary system and the principle that I mentioned to you earlier, that judges are not supposed to raise arguments for parties. It's up to you to decide how you want to prosecute your case, and then we decide it neutrally. So that's something that's always been a real foundational principle for me as a judge, and something that I think is really important to keep in mind on every single case. And a few other things so I was talking about how the cases come up. They start in the trial court, they go to the Court of Appeals. If you're still not happy with what happens in the Court of Appeals, you can file an appeal to the Texas Supreme Court if it's a civil case, or to the Court of Criminal Appeals, which is basically like our Supreme Court for criminal cases. And we don't have to take your case. We get to choose which cases we hear every year. We get about 1,000 petitions every year, and we choose about 100 of those cases to hear. And we're looking for the cases that, where maybe courts in different parts of the state disagree on what the law is, so that we can settle the rule for the whole state and everybody will be following the same rules in Texarkana and in El Paso and in Amarillo and in the Valley. Also, if it's just an issue that's important to the state, or maybe there's some issues of law that there's some confusion about that really need to be settled for the whole state. Because, one of the real fundamental things about the law that I learned when I was advising clients, when I was in private practice, is, it's really important to have certainty and predictability about what your rights and obligations are under the law, and be able to have opinions from courts like mine that clearly explain those things, so that you can rely on that in deciding on your personal affairs and deciding on your business affairs, and you can count on, if something goes wrong, that's going to be the law that the court's going to apply to get you out of whatever that situation may be. So that's something that we look for as well in deciding which cases we're going to hear, and also in writing our decisions, so that we can be sure that we're writing decisions that are clear and easy for people to understand what the law is, and leave the law a little bit clearer than we found it. That's a good day, in my opinion, if we can do that. So those are some of the things we think about in deciding which cases to take. And we're always looking at, as I mentioned, what is the law here, not, what do I personally think the law should be? Because there are, for the most part, the cases that we hear, there's either a constitutional provision or a statutory provision that's been passed by the legislature that's on point, that's going to decide the case, or there may be procedural rules and what have you, that's the issue that's come up in the case. And those have all been set out beforehand. They've been passed by the legislature, or they've been voted in by the people in the case of constitutional amendments. And so the rules are set, and the question for us is, how do they apply to the particular facts of the case that are in front of us? And there's a couple of ways you can think about that. The way that I like to think of it is, what do the words mean, and what would they have meant at the time they were adopted? That's a so-called originalist view of the language, but it also taps into what I was talking about earlier. Everybody ought to be able to figure out what the law is, right? So if you go and look at a state statute that was passed 40 years ago, you're going to want to see what the words say, and maybe look some of them up in the dictionary, or maybe the statute will define some of the words for you so you can figure out what they mean. But the average person reading that is not going to know what they said in some committee hearing about the bill, or be able to dig that up and see maybe what letters went back and forth, or what some senator or representative said about that law on the floor before they passed it. You're just going to look at the words. And so that's what we do on the court, is we look at the words, so that we're looking at the same thing that you would be looking at to try to decide what the law is. There's also a view that, that judges have more discretion to sort of change the law to suit whatever they feel like their personal goals or sort of undergirding principles or perhaps sort of evolving standards of morality or that sort of thing. That's more of an activist view of it, or the law as a living document. And there are several judges who subscribe to that view. By and large, in Texas, we tend to take more the originalist and the plain meaning view, because the view of the law as sort of a living document and being able to change as morality changes. Judges just aren't, we're not selected to be sort of determiners of what the popular morality is at a certain time. And so that's not our job, that's not our education and experience, that's also something that's very subjective, and it's hard for somebody who's reading the statute to say, well, what might a judge think the morality of this particular law is, and how might he or she change it? It's very uncertain. And so the approach that our court has taken here in Texas is more on the plain meaning and the originalist side. But there are those different philosophies out there, and sometimes you see those play out in the selection process for judges. And there are a lot of different ways to select judges. Here in Texas, we elect all of our judges, and that's for historical reasons. After the Civil War, during the Reconstruction period, all of the judges were appointed by the Reconstruction government. And so as soon as we started electing people again in Texas, they put in a new constitution, and we're currently under the Constitution of 1876. And the decision was made, we don't want any more appointed officers at all, so we're going to make everybody elected, from the governor all the way down to school boards and sort of the most local offices that you can think of, the smallest districts that you can think of. All of those people are elected, and that was the philosophy stemming from their personal experience at the time, and the reason that we came to elect all of our judges in Texas. Of course, in the federal system, the judges are nominated by the president, and then they have to be confirmed by the Senate, and we're seeing this now in Judge Barrett, Judge Amy Coney Barrett, who was just nominated by President Trump and has had her hearing now in the Senate Judiciary Committee, and according to the news reports, I guess will be on the floor of the Senate, the U.S. Senate next week for a vote on her confirmation. So that's a totally different way to select judges, where people who are elected by the people are the ones that are more directly involved in the selection. And there are a lot of methods in between. There are a lot of different states around the country, of course, and each one of us has the power under our own Constitution to decide how we want to select our judges. And so a lot of different states do it in different ways. You have some states that will appoint a judge, and then they have to stand for what's called a retention election, where they'll serve for a few years, and then it will be just that judge's name on the ballot should he or she continue in office to be a judge. They don't have an opponent, so they're running on their record, basically. There are some states that do it that way. Some states have nonpartisan elections for judges, where it's just a bunch of names on the ballot and you choose. Some have hybrids of that, where there's a nominating commission of lawyers and judges from across the state who come together and propose a slate of names to the governor, and then the governor picks from that list. So there are lots of different ways that you can select judges. But as I've mentioned to you, we do it in Texas by partisan election, just like any other political office. And in probably the other end of the spectrum is what we do in Washington, with the president appointing and the Senate confirming, and not having any popular vote involved in it at all. Actually, interestingly, we've had a lot of conversations in Texas about whether we should continue to select judges the way that we do, and I would urge you, if this is a subject that you're interested in, to talk to your legislators, your state senators and state representatives, because it's going to be a topic that's going to come up again in the new legislative session that'll start in January of 2021. The legislature passed and the governor signed last session a law to create a commission to study all of these different ways of selecting judges, and to issue a report at the end of this year so that the new legislature will have a sense of how all these states do it and what are the pros and cons of each of those different ways of picking judges. So I'm looking forward to their report, and the legislature will be taking a look at that next session. So this is an ongoing discussion of are we doing it the way we want to? Should we look at other ways of selecting judges? But the way that we select judges in the federal system is, as I mentioned, the president appoints and the Senate the president nominates and the Senate confirms, and we're going through that now with Judge Barrett. And there are ethical rules that prohibit me from endorsing Judge Barrett, so I'm not going to say anything about whether I would vote for her if I were in the Senate. I have had the privilege to meet her. She came and spoke at an event, a legal event here in Houston a few years ago, and I was certainly very impressed. She very personable, very this was actually a Christian-based event, and so she got to speak some about her faith as well as about her legal background and her jurisprudence. So it was really interesting to hear from her about those subjects as well. Very thoughtful, very smart, very personable. So it was a privilege for me to get to meet her, and now the American people have gotten to see some of that through her confirmation hearings. And it's over the last probably 20 or 30 years, the confirmations have gotten to be particularly contentious for U.S. Supreme Court justices. And I think there are different people have hypothesized different reasons for that. One of the ones that I was reading about in the last couple of years that I think is interesting is we've seen a lot of gridlock in Congress these last few years, and there are very few bills being passed as compared historically to what you used to see in terms of the output of laws from the U.S. Congress. And in an environment like that, the courts take on a lot more importance, because if nothing's being changed through the legislative process, then the only other ways to change it are either through the executive process to elect a president who's going to change things that the president can change, which is not everything, but there are some things that the president can change on his or her own. And then for things that the president can't change, you really have to look to the courts to say, is maybe this law unconstitutional, so we shouldn't have this one here? Or, if you have a more activist type argument, is this law contrary to what the popular morality is, and so maybe the court should change it there. And so one theory that I've read about that I think is interesting is that because of Congress, the changes that Congress is making to our laws continue to decrease, it increases the importance of the other branches, the executive branch and the legislative branch, and they're being asked to do more work. And so in that sort of environment, you would expect that people would pay a lot more attention to the confirmation of Supreme Court justices. And so that may be one explanation of why we're seeing the type of focus on that proceeding, this type of confirmation proceeding that we are seeing. And so that's what we're going through right now. I think that may be one reason why it is contentious. But also, I think in these partisan times, we're also seeing people come up with arguments about, should this nomination be made by a president of one political party or another? And of course, the system that we have now, federal judges can serve for life, or at least for good behavior, as the Constitution says. They can be impeached and removed from office if they don't meet that standard, but that's relatively rare. And in fact, we've had cases in the past. There's a book that was written a number of years ago called The Brethren that documented some of the problems that as federal judges continue to get older and stay on the bench, sometimes they know when to leave and sometimes they don't. And so The Brethren talks about Justice William O. Douglas serving basically past the time that he was competent to continue as a Supreme Court justice and the problems that caused. But nevertheless, we have a system under the federal Constitution where judges can serve basically as long as they're able to or think that they're able to until they're removed. And so the timing of a vacancy coming up is not predictable. In Texas, we can serve until we're 75, and then there's a transition, some rules that go into effect about when you have to go off the bench once you turn 75. So we don't have that particular issue here. And we also have regular terms. So I'm on the ballot for a 6-year term, and sometimes you end up running for a piece of a term that's still left, but by and large we run, the appellate judges run on 6-year terms and trial judges run on 4-year terms. So it's more predictable under our system when a vacancy will come up, whereas in the U.S. Federal judiciary, as I said, they can serve for as long as they feel like they're able to. And so when a vacancy comes up is much less predictable. And if it happens to come up at a time that one party or another feels like is not a particularly good time for the way that they feel like the court ought to be deciding cases, then you get a lot of consternation and a lot of focus on, is it appropriate for this seat to be filled at a particular time and that sort of thing. And of course, we've been seeing a lot of that right now. So I think that's another reason why sometimes it tends to be controversial, because the timing is not predictable of when those vacancies will come up. And so those are some of the things that we're seeing right now. And it will be interesting to see. Probably this week, the Senate will have a vote on Judge Barrett, and it looks fairly likely that she will become Justice Barrett and be the junior justice on the U.S. Supreme Court going into their fall term. They've just started hearing cases. They start in October hearing cases, and so she will be able to hear, if she's confirmed this week, most of the cases from this term. The way it works at the U.S. Supreme Court is that they are not able to participate in deciding a case if they weren't there for the oral argument on the case. And so some of the cases from October, she probably will not be able to participate in from earlier this month that they argued, but most of the cases she would be. We have a different rule actually at the Texas Supreme Court. As long as you're there before the case gets decided, you can listen to the tape of the oral argument and participate. So when I was appointed by Governor Abbott in February of last year, I did have to be confirmed by the Senate, because I was, when you're appointed rather than elected, if there's a session of the legislature that intervenes between the time of your appointment and the next election, you have to be confirmed. And so it took about a month for me to go through that process, but our confirmation process in Texas is quite different from what you see in Washington. I did have a chance to visit with most of our senators and was really honored to do that. I went before the Senate Nominations Committee and had a hearing, which was very much shorter than Judge Barrett's hearing. It was just probably an hour, but my family got to come, and it was a very special occasion for us. And they did ask me some questions about my background, my qualifications, and my judicial philosophy, but it was not a 3-day affair as we've seen in Washington. And in the end, I was honored to be confirmed unanimously by the Texas Senate, including all the senators of both parties. And so it's just a very different approach, what they're looking for here in Texas versus what the process has turned out to be in Washington. So there are different, even if you have a confirmation process, there can be different ways to approach that, as those two examples illustrate. But in Texas, we always have, even if you are confirmed and you're appointed by a governor to fill a vacancy in the middle of a term, you always have to run in the next election. And so that's what I basically, since I was appointed and confirmed last March, I've not only been doing my job, but also running a campaign across the state. And so that's obviously not something that Judge Barrett has to do. If she's confirmed as Justice Barrett, she'll serve for life there. So again, another reason perhaps that the hearings look different, because this is the one and only time that other elected officials are going to have, or other participants of any kind are going to have a say in her service, whereas our judges stand for election periodically. So it's a little bit different process that may lead to that different confirmation, what you're seeing as far as the confirmation goes. So I think I'll end it there, and I'm delighted to take any questions. And I don't know, Robert, if you...
Get the mic up here.
You bet.
So, there we go. I wanted to prime the pump with the first question, and then we'll ask. I know everyone on the front row has a question. No, I'm just joking. But we wanted to open it up first to the teens, any teens that wanted to have questions. But one thing I'd like to pose to you is, given, as you said, that Texas, our Supreme Court has more of an originalist viewpoint, and a lot of the federal judiciary has more, or at least some of the justices and some of the different appellate courts have an activist, living Constitution viewpoint. Do you think that makes the stakes of these nominations to the federal judiciary very important to one party or the other?
Yeah, absolutely, and I think it's important for any judge that you're selecting, but it's something that is a little bit harder, I think, for voters to get a good sense of when you have a system like ours where we're selected by the voters unless there's a vacancy in the middle of the term, as there was in my case, but then standing for election in the next election. Whereas the senators have a chance to sit down with the nominee and ask these sorts of questions going back and forth, so they're able to dig in a little more on those philosophy questions about what is appropriate. And so, yes, I think you see, that the senators have a particular view of what a judge ought to do. Should it be more originalist and based on the plain language of the law, or should it be based more on sort of morality and the living laws or living Constitution? And I think different senators hold different views on that, and so they're understandably either trying to defend their approach or to perhaps discourage others from supporting the nominee if they feel like he or she doesn't have that approach. So that's absolutely one of the things that we heard a lot about in the confirmation hearings, and I think will animate a lot of the votes that the senators ultimately take, because they do get that chance. They personally have views about what the right approach is, and then they're able to ask the nominee about those and sort of play that up going into the final decision making.
So teens, if any of the teens have a question, raise your hand, and I want to, just for his benefit, I want you to understand there are some things that sitting justices cannot answer because there are issues that may come up before the court, and he can't put himself in that position. That's just not allowed. So if he says that, don't feel offended in any way. You can ask anything you want, but he'll tell us whether or not he can answer the question. So who do we have? Come on over here, please. Please introduce yourself and then ask your question.
Hello, I'm Nathaniel, and my question is regarding the jurisdiction between the federal and state governments. So, for example, regarding environmental and health regulations, there are sometimes like 3 or 4 agencies, like you have federal level, state level, sometimes city and county level. So where exactly is what determines the powers of the state and the power of the federal government?
That's a great question, and thank you for that. Basically what determines the power of the federal government in the first place is the Constitution, and we have, our federal Constitution creates a government of limited powers, and it spells out in the Constitution, these are the powers that are being given to the federal government. And so the federal government can only legislate on those specific topics. And because of the way that some of those topics have been interpreted, some have been interpreted much more broadly than others, like the Commerce Clause, the commerce power to regulate commerce, interstate commerce specifically in the federal Constitution. And so a lot of the environmental laws you mentioned and health and safety fall under that grant of authority. But then the Congress has to decide how much of that area they want to regulate, because just because the Constitution allows the federal government to regulate something, they may choose not to do it or choose only to regulate it in part. Whereas the state governments are not governments of limited powers. They have general plenary authority to regulate unless their constitutions say otherwise, but by and large, the states can legislate on anything in any subject that they want, unless there's something in their constitution that says no. So a lot of health and safety and environmental regulation is done at the state level, and then the states will create laws about how much local governments can regulate those issues, and sometimes they can regulate it a lot, sometimes not very much, depending on what the state's choice is about should we have that regulation all at the state level, or should we push some of it down to the local level. And so in Texas, on some of those issues we mentioned, you're right, there's a mix of federal, state, and local standards on a particular topic like health and safety or environmental regulation. And sometimes there will be allegations that more than one of those laws has been violated, and so you may see a suit if it's a law that a private person can sue to allege a violation. You may see a lawsuit being filed that alleges violations of all of those things, or if it's something that the state through its prosecutors, or the federal government or the local government through its lawyers basically has to enforce, then sometimes you'll see conversations between the U.S. attorney and the district or county attorney and the Attorney General's office about who's going to bring this case, right? Because we all have laws on the subject, but which does it make sense for which entity to pursue it? And so sometimes they have to cooperate and say, well, this one makes more sense for the state to pursue, or this one makes more sense for the local government to pursue. Great question, thank you.
Who else has a question? Raise your hand, please. Someone over here. Okay, Catherine, you have a question? Okay, that's my daughter.
I don't think you did. But yeah, my name's Catherine, and my question was, so if a law is overturned in whatever court it may be, how long would it take for the effects to come into play, and what would it look like? For example, if Roe v. Wade was overturned, then in Texas and throughout the U.S., how long would it take for those effects to be put into practice, and what would it look like?
Well, that's a great question, because each case has to start in the trial court, like I was talking about. And so if you have a law, say we have a state law that somebody is alleging violates a provision of the state constitution, the trial court can say, yes, I agree, that law is unconstitutional, and strike it down. But usually they're going to stay the effect of that ruling until it can be appealed and heard by a higher court. And so then it will go to the Court of Appeals, and if the Court of Appeals, say the Court of Appeals thinks it's constitutional and they rule the other way, then they can come to our court if it's a civil case, or to the Court of Criminal Appeals if it's a criminal case, and then we get to decide which side do we agree with the trial court that it's unconstitutional, or with the Court of Appeals that it's constitutional. And that process can sometimes take a few years to go through all of those steps. Unfortunately, we're always trying to reduce that time, because it is, I remember when I was in private practice and my clients would get frustrated with how long it takes sometimes to get things through the court system. And that's one reason that when I was first practicing, it would sometimes take the Texas Supreme Court 2 or 3 years to decide a case. And now, for the last few years, we've cleared our docket every year, like the U.S. Supreme Court does. So any case that we agree to hear at the beginning of our term in September, we will always decide it by June, because we want to get those cases out and keep the decisions moving, so that people aren't waiting for a really long time for a decision. So it could take several years sometimes for a case to work its way all the way up through the court system. And then once we make a ruling about whether we say the law is unconstitutional, then there would be questions about, well, how does that apply to other laws that might be similar to this, or maybe in other states, and things like that. So it can take a while to percolate through the system. And if you want to look for an example of that, just look at Brown versus Board of Education, where they said, separate school segregation violates the Constitution. But there were many follow-on cases to that for several years in different states and different parts of the country for that to be fully implemented. So it can take quite some time.
Any other teams that have questions?
Hello, my name's Jackson, and when it comes to a criminal case, how do you decide where they go if they are, let's say, announced yes, guilty?
So if there's a guilty verdict in the case, of course, everybody in a criminal case is entitled to an attorney, and if you can't afford an attorney, the state will appoint one and pay for one. So your attorney if you're found guilty, can file the appeal, and if you're charged in a state court with a state crime, then that case will go to the state court of appeals for whatever jurisdiction is included there. So in Harris County, for example, that would go to one of our local courts of appeals here that hears appeals from Harris County and 9 other counties. And we just happen to have 2 in this area, but it would go to either the 1st or the 14th Court of Appeals. If it's a federal crime and you're charged in federal court, then it would go from the federal district court to the U.S. Court of Appeals for the Fifth Circuit, which hears appeals from Texas, Louisiana, and Mississippi. And then from there, it could be appealed to the U.S. Supreme Court, but again, they don't have to take your case. They could choose to, and they do hear some criminal cases every year. And on the state side, if you go to the Court of Appeals and don't get the outcome you want, you can appeal to our Court of Criminal Appeals, which is not my court, but our sister court that's basically like our Supreme Court for criminal cases. And it has 9 judges who just do that criminal side of the law. And again, they get to choose whether to hear the case. But the one wrinkle is, if you have a challenge to your conviction based on a federal law in state court, so for example, you could say, well, the police officer violated the Fourth Amendment because he didn't have a search warrant when he found whatever this incriminating evidence was, that wasn't properly obtained because he didn't have a warrant and one of the exceptions doesn't apply. That's a federal law-based argument that's rooted in the U.S. Constitution, but you can raise that in state court. And if that's the case, then you can take the case all the way to the U.S. Supreme Court. So you could start state court, trial court, state court of appeals, state court of criminal appeals, and then you could go to the U.S. Supreme Court from there. And it's the same in our court. If we have a federal law issue that's raised in state court and people don't agree, like we had one last year involving the Episcopal Church, which has split in some parts of the state, and one of the questions is, who owns the church buildings? Is it the congregation or is it the denomination? And we issued a decision on that, and there are some First Amendment freedom of religion aspects of that case that we wrote about. And so now there's one of the parties is seeking review in the U.S. Supreme Court on just those federal law issues. So we're the last word on all state law issues, but if there's a federal law issue raised in the case, then it can go up to the U.S. Supreme Court from us or from the Court of Criminal Appeals.
Any other questions from teens? Theodore, you have one?
If you could change one thing with the court or like any court of rank, order, or anything, what would it be?
That's a great question. You know, one of the things that I spend a lot of my time on is access to justice in civil cases. I'm the court's liaison to the Texas Access to Justice Commission because, as I was saying, in criminal cases, if you can't afford a lawyer, the state will appoint one for you and they'll pay for it. But in a civil case, if you can't afford a lawyer, you're on your own. And there are a lot of things that we have done already to try to help people who can't afford lawyers be able to access the legal system and get their business done fairly and efficiently. But there's always more that we can do. And just as an example, one of the few of the things that we try to do is encourage lawyers to volunteer their time for free to help represent people who sometimes are in very dire circumstances. I mean, unfortunately, we've had an upsurge in domestic violence during the pandemic, and you know, some of those cases come to civil court to ask for a domestic violence protective order, but that can be a process that's very intimidating for somebody who doesn't have a lawyer. And so we now have forms that they can fill out that give them guidance on what kind of information the court needs to decide whether to grant protection in a case like that. That's one thing that we can do to help. And so I would like to see more of that kind of effort for cases where people may be representing themselves. We see this a lot in landlord-tenant cases where people can't pay their rent and they're facing eviction, which is an especially complicated circumstance right now because of the people that have lost their jobs during the pandemic. And we have been able to do something to help there, actually partnering with the governor and using some of the federal emergency funds that we got from the COVID relief package, we've created an eviction diversion program where landlords can still get paid for the rent, but the tenants don't have to pay it back right away if they've lost their jobs. And so we can help people have safe places to shelter, but avoid putting landlords in the position of not being able to pay their mortgages. So there are difficult problems there, but I think there's always more that we can do to try to encourage more lawyers to volunteer their time for free to represent people who are in need and can't afford a lawyer. And there's more that we can continue to do to try to make the system simple in cases where it's common that people don't have enough money to pay for a lawyer, to have forms and resources where they can get good advice about how to access the legal system so that our courts are open to everybody.
Last call for teens, and then back here, we have someone back here. Oh, okay, right here. And then we'll go and open it up to the floor. There you go.
Okay. I have a couple of shorter questions that are kind of all related. So first of all, how often are cases determined in the U.S. Supreme Court based on a 5-4 vote?
It varies by term, and it's usually much less than you would think. It's probably 10% or less in most terms, which you would never know from reading the media coverage. But a very large, probably over half the cases are unanimous coming out of the U.S. Supreme Court, actually.
So judges are supposed to use the Constitution as law, right, and not use their own personal beliefs to determine the cases, correct?
That's my view.
Right, okay. So if they're technically all using the same law, then why in those certain cases where there's 5-4 votes, is there a 5-4 vote? Is that because of personal beliefs? Is that because those are coming in?
Well, I mean, you see 5-4 decisions in our court too, and I think, most of the justices on our court go more with the plain meaning of the words, but partly it's because sometimes words are not clear. Despite our best intentions, language has ambiguities in it, and the people who were writing the law may not have thought about all the circumstances that could come up that could test the meaning of those words. And so sometimes you end up with words that don't perfectly answer the question that's before the court.
All right, thank you.
Thank you.
Okay. So how are justices allowed to change the law, or are they only supposed to use it when they're judging cases?
Well, we only use it in applying it to particular cases, and so there are certain parts of the law that are called the common law that have been developed by judges from the beginning, and there's not a statute from the legislature or there's not a constitutional provision on point. And those are areas where the judges can change the law in a particular case if there's not a statute on point, because the law is just based on prior court cases going back. And we inherited that tradition from England as well, that on subjects where the Parliament, or in our case, the Congress or the legislature hasn't spoken and the Constitution doesn't speak to it, then the courts have created rules over time about and much of our contract and tort law is based on the common law, although a lot of it has been since put down in statutes. And so if it's in statute, the court can't change it. But if it's based on the tradition and the prior decisions, then that's one that we can take a look at again and say, there wasn't an exception here before. So just to give you an example, we had a case last year where there's generally a rule when you have, in deciding whether an insurance company has to defend you if you're sued for something, does it fall within the insurance policy? You just look at what you're being sued for and what the insurance policy says. But this last term, we had a case where it was admitted that the insured and the person that ran into her got together and agreed to lie to the police and the insurance company about who was at fault in the accident. And we said in that particular case, you can also consider that testimony that they were lying. You're not limited to just looking at the lawsuit and the insurance policy. And so those are sometimes you end up with exceptions like that need to be made because it wasn't something that was at issue in the prior court case that set out that rule that you only look at these two things. And so we can change rules like that, but if it's in the Constitution or it's in the statute, then it's up to the Congress or to the people to change it.
Who else have a question? Over here? Okay. Come on up. Here you go. Introduce yourself.
Hello, my name is Walker Hughes, and I was wondering at what point with California prosecuting people that are meeting in churches, at what point does the First Amendment come in and says you can no longer fine Christians and other religions for meeting together?
Well, that's a great question, and that's one that could come before our court. So I can't speak to that as far as, at what point the First Amendment could come into play there, because the ethical rules that we have, if I were to offer you an opinion on that and then the case came before the court, I wouldn't be able to hear it because I had already explained what I thought my view of the law is. And the reason that we have rules like that, and I appreciate the question, and it's certainly one that's on a lot of minds around the country right now, but the reason we have rules like that is because to encourage judges to wait and see all the facts of the case as it comes to us and all the legal arguments that the parties are making and decide the case just based on those things. If I started thinking about, well, there could be this legal argument, that may or may not be the argument that the parties actually make in the case that comes to me. And so I'm not their lawyer. They need to decide for themselves what arguments they're going to make, and then my job is to decide whether those are in accordance with the law and the Constitution. So we'll have to wait and see if we get a case like that here in Texas.
Very good question, though. Okay, we have time for a couple more. Any? Raise your hand if you have a question. Here you go, right here. Introduce yourself, please.
Hello, my name is Isabella, and my question is about when you first became the Texas Supreme Court Justice, what were your initial goals when you became it?
Well, I appreciate that question, and I had several goals. One was so I'm the only justice on the court currently who had a background as a civil appellate specialist, arguing cases in the Texas Supreme Court. We have a lot of different backgrounds on the court, but I think that's a unique perspective that I bring to the court, and I wanted to be sure that I was thinking about the cases from that perspective and being sure that we take, number one, that we take the cases we need to take from all around the state to be sure that the law is, as I mentioned earlier, as settled and predictable as it can be, and then writing clear opinions that take into account not only the law, but also the proper procedures that apply on appeals, which is something I spent a lot of time learning as a lawyer, so that those are consistently applied to everybody, because in my view, it's as important that everybody have the same procedural rules that they have to go through as that the same substantive law apply to everybody. It needs to be fair both from a procedural standpoint and a substantive standpoint, and everybody needs to be held to the same rules and laws from that perspective. So that was important to me. And then also, I mentioned earlier the Access to Justice Commission. Although a lot of our work is deciding cases, we also oversee the whole judicial branch as members of the Supreme Court. So we have a large administrative docket that has nothing to do with deciding particular cases. And actually, we've been extraordinarily busy on that the last several months during COVID, just trying to keep our courts open and functioning so that we can continue to deliver justice safely. And we've done a lot of that with Zoom and having electronic hearings and things like that. There are some proceedings that still need to take place in person, but I'm really proud of what we've done. We're one of the leaders in the country now. We've had hundreds of thousands of hearings now using technology. And one of the things that I'm always looking for is what new can we learn to make the court as fair and efficient as possible? And actually COVID, one of the silver linings, I think, is it's given us a great idea of how can we use technology going forward, even after the pandemic, to help make our system as fair and efficient as possible. And I think electronic hearings certainly are going to continue to have a place even after COVID, because if you just think about it, there are a lot of parties in cases and witnesses who, if they're not at work, they're not getting paid. And so if they have to take off all day and go downtown and pay to park and sit around and wait for their case to be called, you know, that's money that they're not making for them and their families. But if they can go to a quiet place and just get on their smartphone and be right there in the courtroom, it's a lot more efficient for them, and it's more efficient for the judge too, because they know when when each case is going to come up. They can set a particular time, and the lawyers don't have to charge the client for driving downtown or maybe driving several counties over in some of our more rural regions of the state. Their clients are not going to have to pay the lawyers for that time if they can just sit down at their desk and be right there in the courtroom. So that's one of my goals, is to continue to look for ways like that we can make our court system as fair and efficient as possible.
Also, one more question about what are some achievements you've made regarding clarifying important Texas laws that were unclear before?
Well, let's see. So one case that we had last term that I wrote about was about the ownership of stream beds near the Gulf of Mexico, which is actually important to a lot of owners of property down there, where you have stream beds that are influenced by the tide. So the tide may come in and out, but then during other times the water flows as normal, and there has been a lot of confusion in the law for many years about, well, for one thing, which system of law even applies to that, because in Texas we have a Mexican law heritage through the civil law from before, when Texas was a republic, and then we also have a common law heritage from after we adopted the common law as a state. And there are different systems that can apply to stream beds like that. So we wrote an opinion to try to clarify all of that and say who owns the stream beds in that area of right along the Gulf of Mexico. So that's just one example.
I think unfortunately, we've run out of time for questions. So let's thank Justice Busby for coming this evening.
Thank you for having me. It was a pleasure.
And have a seat up here if you like. I'd like to ask our pastor to come up, and if he would, just pray a prayer of blessing for Justice Busby and the election. And I want to remind everyone, of course, that as he said, our Supreme Court justices are elected, and we have this fine justice on the ballot. So if you haven't voted yet, look for his name and consider that race there. And Pastor.
I think after hearing, I'm reminded again how, in a good way, I'm proud to be a Texan, happy to be a Texan. There's no state like this state anywhere near this state. This is the state, amen? And that's what I say about this church. No church like this church anywhere near this church. This is the place. I think I even messed that up. It's late, but anyway, I want to thank you so much, Justice, for being here. Man, I learned some things, and I appreciate it. Also, I'm impressed with the intelligence of our kids. Yeah, wonderful. All right, yeah, praise the Lord. Great. Every question was spot on. Matter of fact, I didn't know what some of you were talking about. It was great. Let's go to the Lord in prayer. Heavenly Father, we thank you so much for allowing Justice Busby to be with us at this hour. I know there's so many places he could have been, and probably a lot of places that would have been more advantageous for him in seeking his office to be brought in to reality for another 6 years. But thank you that he chose to come here. We're reminded again of what Romans 13 says, and that is the powers that be are ordained of God. And we're thankful, Lord, that we have a man that's consumed with doing the right. And so, Father, I just pray that in this coming election that right will be done. Let the kingdom of God come. Let the will of God be done. So bless this precious justice and his family. Give him good health. Continue to give him wisdom beyond his years and beyond himself. May it come from thee, O Lord. For thy word says every good gift and every perfect gift cometh from above, from the Father of lights, with whom is no variableness neither shadow of turning. And now may the grace of our Lord and Savior Jesus Christ, the communion of the blessed Holy Spirit, and the love of God our Father be with us now and forever. In Jesus' name. And the people said, amen. Thank you. Praise the Lord.